This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about an inadequate litigant whose cases were dismissed because by her attempts at litigation she appeared to establish that the report asking that she be given a mental health evaluation was clearly appropriate. In Samrin Rias versus State of California et al., the California Court of Appeal on December 2, 2024, found itself asked to resolve suits against an individual and the State of California from an inadequate but excessively litigious plaintiff. Samrin Rias was a licensed dentist. She lost her license to practice because of the facts underlying the case. According to her, there is an elaborate conspiracy to harass, stalk, threaten, and ultimately prevent her from testifying in separate whistleblower cases involving OSHA and HIPAA violations at a medical facility. Riaz sued, raising numerous claims against numerous individuals and governmental entities. The opposing parties challenged the complaint's viability through demurrer and anti-SLAPP proceedings. The trial court sustained the demurrers and granted the anti-SLAPP motions, leaving Riaz with no viable claim. She, of course, appealed. The facts underlying the case involve four discrete events. First, Riaz sued a medical facility and suffered an alleged eye injury while attempting to testify in that case. Second, she sought treatment for the eye injury but was refused service and then sued that doctor in small claims court. Third, the doctor reported Riaz to the Dental Board of California, which in turn initiated mental health competence proceedings against Riaz. Fourth, Riaz's license to practice dentistry was revoked, and she filed the complaint at issue in this case. Acting as a whistleblower, Riaz disclosed OSHA, HIPAA, recruited patient, potential insurance fraud, and anti-competent activities in the market at a medical facility. After filing a lawsuit on that basis, Riaz claimed she suffered organized harassment culminating in permanent eye damage after a sheriff's department employee pointed a finger in her face while attempting to enter the courthouse in her whistleblower case. Riaz visited Dr. Cantrell to treat an eye injury. She claimed Cantrell became combative, refused to answer her questions, and declined to treat Riaz. The next day, Riaz filed a complaint with the Medical Board of California. Several days later, she filed a small claims case against Cantrell, essentially alleging discrimination, negligence, and retaliation. A small claims judgment was eventually entered in Cantrell's favor. Cantrell reported Riaz to the Dental Board. The Dental Board issued an order to Riaz to comply with a mental health examination to evaluate her fitness to practice safely. Riaz failed to comply with the order, and since Riaz continued to disobey the order, her license to practice dentistry was ultimately revoked. Riaz sued then Cantrell in this case, and various governmental entities and several individuals working for those entities. The complaint alleged an elaborate conspiracy among all the defendants to injure Riaz, to intimidate her, to prevent her from testifying, and to retaliate against her for the whistleblower case. The trial court sustained the demurrers and granted the anti-SLAPP motion, resulting in total dismissal. The Court of Appeal was asked whether the trial court erred in granting the anti-SLAPP motion and in sustaining the demurs. The California Court of Appeals concluded that the trial court did not err. In the anti-SLAPP motion, Cantrell argued his furnishing information to the dental board was protected activity and defeated claims for discrimination, fraud, defamation, retaliation, and intentional infliction of emotional distress. In opposing the anti-SLAPP motion, Riaz claimed, again, Cantrell made inaccurate, knowingly misleading statements to the dental board to defame and harm Riaz based on disclosing patient information. The trial court concluded furnishing those documents to the board constituted protective activity. The Court of Appeal then, analyzing the issues, noted that litigation of an anti-SLAPP motion involves a two-step process. First, the moving defendant bears the burden of establishing that the challenged allegations or claims that arise from protected activity in which the defendant is engaged. And second, for each claim that does arise from protected activity, the plaintiff must show the claim has at least minimal merit. If the plaintiff cannot make this showing, the court will and did strike the claim. If there is no merit, the claim was stricken, and the Court of Appeals noted that Riaz failed to adduce any evidence, including exhibits, declarations, judicial notice, and testimony to substantiate her allegations that Cantrell reported her to the dental board for retribution. She failed to adduce admissible evidence on that point. Both Cantrell and the state also filed demurs to Riaz's complaint, and noting that a small claims plaintiff is collaterally estopped from relitigating the same issue in Superior Court where the record is sufficiently clear to determine that the issue was litigated and decided against plaintiff in the small claims action. Governmental immunity is an affirmative defense properly raised by demur, and Government Code Section 821.6 immunizes public employees from liability for instituting or prosecuting any judicial or administrative proceeding within the scope of their employment, even if the employees act maliciously and without probable cause. Riaz alleged her claims arose in July of 2022. Her written government claim was submitted in April of 2023, more than 6 months later, and accordingly the claims were barred, at least insofar as they stem from the Section 820 order. Riaz therefore failed to allege colorable claims against either Cantrell or the state. The potential claims against Cantrell were either tried and resolved against her in small claims court or dismissed pursuant to the anti-SLAPP statute. The potential claims against the state were either barred for failure to timely present them under the Government Claims Act, or the state was immune under Government Code Sections 821.6, 818.4, and 821.2. In my opinion, it's axiomatic that a person who represents himself has a fool for a client. The litigation history, the multiple actions, and the lack of consistency and evidence establish that Dr. Cantrell was correct when he advised the dental board that a mental health examination to evaluate her fitness to practice safely was correct. She refused to fulfill her obligation to the dental board to be evaluated because she was concerned she would not pass. This case is an abuse of Dr. Cantrell and the state and should have resulted in serious sanction, but since she was improper, the court decided to just rule against her. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. and you'll have access to the more than 4,950 blog postings. You can also subscribe to these videos at YouTube and or rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you're interested in more detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.